One of the most common questions I get is, Matt, when do I use a trust? A lot of people are like, how does a trust work in building wealth? Like, is this for my estate plan? Is this for asset protection? Why does everyone talk about trusts and what are they? Well, a trust, we like to use them for 99% of our clients who are building wealth for one thing, estate planning. I want to plan your estate. I want your loved ones to know what they're going to get. I want you to put restrictions on the money. I want you to think through this. I want you to pass on a legacy, not a mess to your loved ones when you pass on. Because let's be honest, we will all expire someday. Someone's gonna get our assets. Are you gonna leave a mess behind for your family to fight over, or are you gonna have it organized? Have it go outside of probate, no courts involved, have it pass through a trust. That is why 99% of Americans who are building wealth should have a revocable living trust. Sometimes this is called a family trust. Now let me talk about what this is not. This is not for asset protection. We do not use trust for asset protection. Real lawyers will very rarely use trust for asset protection. Only people pretending to be lawyers or selling documents will sell trusts for everyday investors buying rental properties or stuff like that to say use a trust for asset protection. You're going to use LLCs for asset protection. We might use a domestic asset protection trust for asset protection. But that's only available in 15 to 20 states. The main trust I want you to think about using is simply a revocable living trust. Now here's why you want to use it, and here's some of the things you're going to need to know. First, the trust is going to pass outside of probate. What does that mean? Well, when you die, you need to say who's going to get your assets. If you have a will and you say who's going to get my assets, guess what? Your family's still going to court. They're going to have to go to court, probate court, to have that will validated, and a court to empower the executor of the will to distribute the assets. What's going to happen? That's all going to be public. That will is going to be on file. Everything's going to be at the courthouse for people to see what you have. I don't love that. Most of our clients don't want that. Plus, you're going to have significant legal expenses going through the probate process, like 5 to 10 times more expenses than you're going to have just setting up a trust now and taking care of it. So if you didn't have a will, by the way, you're also in probate court. It's just more of a mess. But the trust, what that does is I now get to pass on my estate outside of probate. I don't have to go to court. The trust is going to own my assets. It's going to own my home. It's going to own my LLCs. It's going to own my business, my retirement account, my life insurance. The trust is going to be the beneficiary on those accounts. Now what's happening when you pass on is the terms of the trust are going to control. And who you designate as trustee is basically the judge now. They get to decide who gets the assets according to the terms of the trust, and they don't have to go to court. Now the trustee could be your surviving spouse, it could be your kids, a friend, a business partner. I mean, you can list someone you trust who's going to know your estate and your loved ones and what you want to happen. And they should get a copy of your trust, by the way, when you sign it. But the trustee is not going to court. The trustee is going to go sell the house and give the proceeds to your kids. They're going to continue the business or the rental properties or the investment portfolio if that's what you wanted. They could pass on income down to the kids. They could go sell all the assets. They could distribute assets directly to the kids and not sell them. Whatever you want, you get to decide. It's your trust. Now, the trust has a lot of things in there that can protect your loved ones. Let's say you got minor kids and pass away. And let's say when they turn age 18, if you just had a will or you had no will, guess what? They're getting their full inheritance at age 18. That is not good. As a lawyer, I've seen that. I've had clients that had passed away with no estate plan. We've had families come in here where someone passed away with no estate plan, and we've had to figure out who gets their assets. And you know what? We've had some that had kids in college. A kid in college got a significant hundreds of thousands of dollars inheritance. What happened to that? It disappeared in 6 months and it jacked that kid up. They bought an Escalade like literally on day one that their inheritance cleared. And so we don't want to mess up our kids with money. We want to be intentional about it. We want to leave a legacy. We want this money and our assets to benefit our loved ones, not create problems and ruin their lives. And so having a plan in place can really help. Let me give some examples of cool things we like to see in trust for our clients. First, if you have minor kids and you pass away, I don't want them to inherit your estate. Not yet. Maybe we give them 1/3 of it when they hit 25, another 1/3 when they're 30, and another 1/3 when they're 35. And before they're 25, maybe they get enough money to pay for college or buy a home or start a business. They're only getting money on a needs base and some type of need that you deem as important and qualifies. In our law firm, we set these up and we help our clients think through these things and go over common scenarios and things we've done with our clients. But then we like to give them the money out in stages. Now you might be in your 60s and be like, you know what, my kids are adults now. They're in their 30s or 40s. I trust them with the money. Cool. We can say that in your estate plan and say, let's let the money get distributed to them. But we might still want to throw some restrictions in, like what if they have a creditor chasing them down? What if one of your kids has judgments against them or they're about to file bankruptcy? We don't want to just go give them an inheritance and have that money go to waste. Instead, we can put a creditor protection clause in the trust that says, hey, when you pass away, if one of my heirs has any creditor issues or judgments against them, the trust is going to hold their money until those creditors or judgments are dealt with. And so that way that money is still set aside and it can pass to them, but it's not going to be gobbled up by a creditor when that money's transferred. Another thing that's common we like to see is, what if one of your kids ends up, unfortunately, and this could be your brother, your sister, your girlfriend, I don't care who your heir to your estate is, but if any of your beneficiaries on your trust have an issue, we may want to put some restrictions in there, like a drug or alcohol addiction. What if one of your kids has a drug or alcohol addiction? I don't want them getting your estate, so we can put a restriction that they only get a distribution once they've gone to treatment or some program or otherwise dealt with that addiction or issue. And so there's lots of things you can put into the trust. The key thing to know is trusts are for estate planning purposes. If you have a significant amount of net worth, 20 million plus, we might be employing some other trust structures, some irrevocable life insurance trust. You might be selling assets in a tax planning type scenario where we're using a charitable remainder trust. But for everyone out there, 99% of Americans building wealth, you should have a revocable living trust. That's the document you need. It's for estate planning purposes because we are all going to die. We will all need this document. But I want you to think about this as building a legacy. A lot of people delay getting a estate plan done because that's not fun. For a lot of people, they think of it as planning their mortality. Think of this as planning your estate, planning your legacy. What do you want all this hard work and time you've put in building wealth to be used for when you pass away? How do you want it to benefit your family, your loved ones, the charities that you value? This is how I want you to approach doing your estate plan. Think of it as strategic planning for your legacy when you pass on so that your money can have an impact in the areas that you value and you cherish. Now, make sure you get the estate plan done. There's lots of lawyers you can work with. Our law firm, KQS Lawyers, would love to help. We help clients across the country plan their estates, but do it with the lawyer you know. If you have a great lawyer that you work with, have them get your estate plan done. The nice thing about it, once it's done, if you change your mind, it's a simple amendment. Don't get hung up on this and be like, well, I'm not sure exactly what I want, and feel like you have to nail it 100%. Get it 95% of the way there and done and signed and in place. If you later decide, I don't want that kid to get anything, maybe I do get remarried and I need to change some things. Easy. You can amend the trust. That's why it's called a revocable living trust. You can revoke it or amend any piece of it or the entire thing at any time. Now, the trust is just one component when you're building wealth, and it's important. Remember, this is about your legacy, but there's so much to learn about this, but it can be fun. Make sure you're subscribed to my channel. I'll be back with more information. Click this video here about retirement accounts. That's a huge component to building wealth that I want you to know about as well. I think it's the next most important thing to learn as you're on a wealth building journey. See you back here next week. Until then, find joy in the journey when you're building your wealth.